Well, I'm going to turn now to ground 1 of the appeal, that is stage 2 of the section 9 analysis, as to whether matters are within the scope of arbitration agreements having been identified under stage 1 of the analysis as being matters within the proceedings. And this argument for the Republic proceeds on the basis that the Court of Appeal has wrongly decided as an immutable principle that if an unintimated defence was an arbitrable matter, then the claim to which it was a defence was also. In fact, there is no such error of principle by the Court of Appeal, and the Republic only gets there by asserting that the Court of Appeal addressed this as a point of principle when it did not. We dealt with it in detail in our case at paragraphs 92 to 102, and I propose to pick up certain points in relation to that and in relation to points made by the Republic in their case. A significant starting problem, by way of difficulty for the Republic on this element, is that the scope of the arbitration agreement is a matter governed by Swiss law, and the Court of Appeal rejected the Respondents' appeal on the first ground of appeal in the Court of Appeal, and therefore upheld and applied the Swiss law as found by the judge, against which, of course, the Republic did not appeal. In consequence, the Court of Appeal was adopting the approach to Swiss law found by the judge below, of which no criticism had been advanced by the Republic. The Republic refers to this matter in its case at paragraph 34, but it's in fact irrelevant. The Court of Appeal rejected the challenge of the respondents on the first ground of appeal in the Court of Appeal, namely as to the judge's treatment of Swiss law, on the basis that the respondents' first ground of appeal was based on criticising the first instance judge, the things which the Court of Appeal found on a proper and full reading of the judgment, he did not in fact say, or certainly mean, rather than that the judge would have been right if he had decided matters in the way that the respondent said he had. So what is happening is simply that the Court of Appeal has looked at the judgment of Mr. Justice Waxman, what his view is on Swiss law, and applied it. So it is difficult to see on what basis there can be a legitimate criticism of the approach of the Court of Appeal. The Court of Appeal held, in relation to the Swiss law issue before it, that the respondent's case, that's my client's case, against the judge's reasoning was overstated. You see that in the Court of Appeal judgment at paragraphs 74 and 75. And crucially, the Court of Appeal determined at the judgment, paragraph 74, that the reality of the respondent's challenge was not to the judge's findings of Swiss law, but to his analysis applying that law to the facts. And we, of course, have not challenged that decision of the Court of Appeal. Indeed, we rely upon it to say that there is no real issue of law at stake on this appeal. It is simply about the application of Swiss law to the facts of the case. That the Court of Appeal has done at paragraph 82. The Court of Appeal, we respectfully suggest, has dealt unimpeachably with the application of Swiss law to the construction of the arbitration agreements. The Court of Appeal first recognised the limited circumstances in which it was legitimate for the Court of Appeal to interfere with findings of fact of this kind.
Where are we now in that judgment? Sorry.
83 to 84.
Thank you.
So they come on to deal with ground 1 at paragraph 73 of the judgment. But the point that I was referring your Lordship to is under the heading ground 2, but 83 says it's important to bear in mind this appeal is limited to a review.
I'm sorry to take you back. The heading to these submissions is which issue before us?
The issue before your lordships.
I'm just looking at the statement of issues. Which one did you start the submission with?
This is ground
You say
one,
So
stage.
issue 1 on page 17 in the statement of facts and issues. Is that right?
Or the second part, I think, that issue.
Yes, so I'm dealing with issue one.
Yes.
So the second part of the test. So what is within scope of the arbitration agreements?
So 71.1.2 is what you're addressing. Is that right?
My lord, yes.
Yeah.
I'm sorry,
okay.
I didn't.
Sorry, no, I think you did say it. I just missed it.
So yes, just to recap, then I am dealing with the Court of Appeal's treatment of the Swiss law construction of the arbitration agreement to identify what is within scope of the arbitration agreements, which is stage 2 of the test under section 9.
Okay.
And it is, and I apologise for having made it slightly more confusing, because the Court of Appeal had 2
Yes.
grounds of appeal before it.
So it's stage 2 under ground 2, is it?
Yes, it is.
I see.
And for the first point that I was seeking to make to your lordships was that the first issue the Court of Appeal had to deal with was my client's challenge to the Swiss law findings.
Yes, I've got it. Yeah.
I'm grateful, my lord. And so there was no doubt that from paragraphs 83 and 84 of what is referred to as ground 2 in the Court of Appeal,
Yes.
i.e. the challenge to the application of Swiss law principles to the scope rather than their ground 1, which was the Swiss law principles. So coming on to paragraphs 83, 84 of the judgment, the Court of Appeal recognised at the outset that on this matter, scope and stage 2 of the test, the Court of Appeal is dealing with findings of fact by the first instance judge about how you construe this clause under Swiss law. And they fully recognised the limitation of the position of a Court of Appeal in addressing issues of fact. And what the Court of Appeal did was to say that there were, of course, limited circumstances in which it was legitimate for a Court of Appeal to interfere with the findings of fact of this kind. But in light of the concession that had been made by the Republic and held by the Court of Appeal to have been rightly made, Mr. Justice Waxman's decision in relation to the IFA and the UMIFA couldn't stand. If you change the position under the clauses and you accept that for the purposes of the arbitration agreements the IFA and the UMIFA are in, that may impact upon how you address, as a matter of construction of the clauses under Swiss law, whether any of the other matters are in. So if you change, as it were, your starting point, and Mr. Justice Waxman said the scope of the clauses is not wide enough to cover the IFA and the UMIFA, concession by the Republic, held correctly to have been conceded by the Court of Appeal, no, that's not right. The scope of the agreement is wide enough to cover the IFA and UMIFA. In those circumstances, the Court of Appeal, with respect, rightfully said, well, we're entitled in those circumstances to look again at the scope of the clause, but we do so in the light of the findings of the judge as to Swiss law, which, as I say, had been challenged by my clients in the Court of Appeal, but we had failed in that challenge. So what the Court of Appeal did was, having established that it was legitimate for them to interfere on the facts because of the wrong position that had been reached at first instance on the IFA and the UMIFA, they then applied the Swiss law principles which Mr. Justice Waxman had found to the other issues as a matter of analysis of the scope of the agreement. And what the Court of Appeal then did was, in paragraphs 85 to 90, consider the IFA and conclude that it was indeed within the scope of the arbitration agreements. And then at paragraphs 99 to 103 and paragraph 105, the Court of Appeal returned to this issue and concluded that the defences to the IFA were the mirror image of the IFA and also arose as defences to the other claims against the respondents and were accordingly similarly sufficiently connected to the supply contracts to be within scope. So they didn't say that the first instance judge had got the Swiss law wrong. They simply said, given that they're starting from a different position in the analysis of the clause from the conclusion reached by the judge, applying the Swiss law that the judge had found, the Court of Appeal came to the conclusion that it did in relation to the other matters in these proceedings. And that is important, not least because one of the criticisms that is made by the Republic is that the Court of Appeal was not in as good a position as the judge, because the judge had live expert evidence before him in relation to as to the meaning and effect of Swiss law. Of course, that point falls away when you recognise that the Court of Appeal wasn't claiming to say that Swiss law was something other than the court at first instance had found. But the court was not disagreeing with the judge's assessment of what was Swiss law. That was where he'd had the benefit and advantage of expert evidence in front of him and been able to exchange with him. The Court of Appeal was saying, given that is the Swiss law, how do we apply it? And that is a matter, with respect, that the Court of Appeal was as well placed to address as the first instance judge, but doing so as it did from the correct starting point, which is that the IFA and the UMIFA were within scope of the agreements as a matter of Swiss law. And then where do you go from there? Because the starting point for them, therefore, rightly in our submission, is that the IFA and the UMIFA allegations are sufficiently closely connected to the supply contracts to come within the scope of the agreement. And therefore, the Court of Appeal says, now let's look at the other matters and see whether they also are sufficiently closely connected. So it's not an error of English law that's being impugned. It's not an error of Swiss law that's being impugned. It is the application of Swiss law to the facts of our case, which comes before you. It's not exactly a high point of English law principle.
Well, the application of the contract as construed in accordance with Swiss law.
Exactly.
What the Court of Appeal says in paragraph 99, they're actually focusing on the IFA, the mirror image of the IFA. They're not focusing on the IFA. They're focusing on your case, that the supply contracts are valid, genuine and bona fide commercial contracts. That is what they say, that that is a defence that is inevitably raised in this case. That's stage one. So having determined that that is inevitably raised and would provide you with a substantial defence, they then go on to consider whether that defence falls within the arbitration agreements contained in the supply contracts. Is that right?
Well, they start with an analysis of whether the IFA claim is within.
Yeah, but we know they do. But that then has been put on one side. We've been all through that quite a bit this morning. But now they're focusing on your assertion that these are valid, etc. contracts, and saying that is a defence open to you, a substantial defence, and then they go on to ask whether that falls within the ambit of the arbitration agreements.
Yes, they are. They say that the defences that we wish to raise are the mirror image of the IFA, and given that the IFA is within scope, they then say those matters are going to be raised by way, those defences must be within scope, and then they look to the question.
Yeah. And I don't suppose there's any dispute between you and Mr. Pillow that if indeed that were an available defence, it would fall within the arbitration agreements.
One would hope not, my Lord. And if one then reflects on the scope of, therefore, what is within the arbitration agreements concerning the IFA and the UMIFA, the Republic's attempt to use the presumed intention of the parties to limit the scope of the arbitration clauses in our submission fails. The IFA and the UMIFA are wide in their scope. The issues that are entrained by the IFA and the UMIFA are of the very broadest. They go across all the contracts, they go across all the participation of all the parties, and they go to the heart of all the factual disputes between the parties.
I'm still struggling, Mr. Matthews, to understand why you were addressing submissions to an issue which we've been told is not pursued against you for this purpose. It seems to me that you're aiming all your shots at the target that's been removed. It's a bit of a waste of time on your part. You'd be better off addressing the one that's still being pursued for this purpose, which is not the whatever it's called, IFA.
I'm sorry, I'm not explaining myself clearly to your Lordship. We're at cross purposes. I do apologise. My fault, I'm sure. I am pointing out that the starting point of the Court of Appeal was rightly that the IFA and the UMIFA are within scope. From that, they conclude also that the matters by way of defence to the IFA and the UMIFA are within scope.
Yes.
All of this is applying accepted principles of Swiss law to the construction of the clause.
Right, but I think, as Lord Richard said, we'd be surprised if there was any dispute about that. So what point are you now addressing?
If you start with that as your premise, the question is whether the Court of Appeal in any way went wrong in saying that any of the other matters are also within scope.
The non-IFA matters.
Indeed. And my point is simply that when
they're not non-IFA matters, because they're matters which the Court of Appeal said the defence relies on the mirror image of IFA.
Yeah.
And that's why they're within scope, isn't it?
So it all turns on that premise, doesn't it? Or whether that premise is correct, that the matters are all brought in necessarily by your defence.
It doesn't entirely turn on that premise.
Right.
And the reason for that is the starting point is what is the correct approach to construction of these clauses. Bearing in mind the criticism which the Republic raises, there must be a sufficient connection. The criticism of the Court of Appeal which the Republic makes is that they didn't apply the appropriate test of sufficiency of connection, and that they should have given due deference to the approach of the judge in relation to that. I've explained why they were entitled to start again in relation to that, and the Court of Appeal took that carefully. I have explained that if you start with the premise that the IFA and the UMIFA are sufficiently connected, one sees immediately that the scope of these arbitration clauses is wide, because the framework and the contents of the IFA and the UMIFA are wide. They are broad in their scope. And a lot of the points that are made in criticism of the judge's approach in relation, the Court of Appeal's approach in relation to the other issues, are undermined by the fact that you accept the IFA and the UMIFA are in scope. So, for example, the multiplicity of parties, the fact that there are some parties continue to be in the proceedings who are not in the proceedings, the fact that there are multiple contracts, all of these matters, they are equally true of the IFA and the UMIFA. And that would be a basis for complaining about the degree of connectivity in relation to the IFA and the UMIFA. But in that context, it doesn't work. It's accepted that they are sufficiently closely connected, despite all those issues, multiplicity of parties, multiplicity of agreements, multiplicity of parties still remaining in proceedings here, even if you take proceedings off to arbitration. All of those matters arise in relation to the IFA and the UMIFA, and yet the IFA and the UMIFA are sufficiently closely connected. So why does that make any of those points a good argument in relation to any of the other points? That's the core point, because if you accept that the supply contract arbitration agreements are wide enough to encompass the IFA and the UMIFA dispute, which is sufficiently closely connected to the relevant transactions to come within the scope of the arbitration agreements, the same must be inform your approach on the other issues. And insofar as your complaints are raised by the Republic that in relation to the other issues there are obstacles to that, namely multiplicity of parties, multiplicity of agreements, multiplicity of people who would still be liable or would be subject.
I don't follow this, Mr. Matthews. I suppose that the starting point were that you don't, because of the multiplicity of contracts, you don't start with a pro-arbitration approach to construction. You may still find that an allegation that the very contract under which the arbitration clause sits is invalid is within the scope of the arbitration agreement. But you might not then hold that it extends to bring in a dispute about whether some other connected contract was invalid as coming within the scope of the arbitration agreement. If you're not applying, it may affect that. The answer to that, how much in favour of arbitration you are pressing the construction.
But the IFA, take for example the Pro Indicus claim in relation to D6. And the arbitration in relation to that. Once you accept that the IFA, as it affects D6, as it affects the Pro Indicus contract, is within the scope of the arbitration agreement for D6, you accept that the D6 arbitration is going to cover the full gamut of the allegations of the IFA and the UMIFA in those arbitration proceedings. By definition, you are acknowledging that the party's approach to this has been to accept that there will be disputes in that arbitration which may impact other contracts and other agreements.
Because they may impact other agreements. It doesn't mean a dispute about the validity of another agreement is within the arbitration clause of this contract.
But it would be, because if you're taking the IFA against D6 in the Pro Indicus, you are looking at all the transactions.
But it doesn't follow, because what you're doing is binding D6 to a decision about the validity of the supply contract. It doesn't follow from that you can bring within the scope of the arbitration agreement for the supply contract a dispute about the validity of the guarantee.
That is the IFA. That you have.
How I just don't understand this. How would you litigate or arbitrate the validity of the guarantee in an arbitration under the first supply contract?
Because it's all part of the package of agreements.
But I mean, Credit Suisse wouldn't be a party, would it?
No.
I see.
But the IFA extends to that debate. If one takes the IFA out of this and takes the IFA into the arbitrations, you will have that debate. And it's something that happens all the time. A standard example would be if two parties enter into an agreement which is subject to an arbitration agreement, but there is a dispute as to whether that contract has been properly concluded or not, there may also be a negligence claim by one of the parties against the broker.
But the arbitrators wouldn't rule on the validity of the guarantee.
But there's no
They'd only be ruling on the validity of the Pro Indicus, if it's that one, contract.
No, they may well be required to rule on the validity of the guarantee. It just doesn't bind Credit Suisse.
But it's not required in order to decide a dispute about the validity of the supply contract.
It is entirely possible that happens all the time in arbitrations, that you have decisions that are made which impact, as a matter of law, only the parties to that arbitration. But of course, issues arise in those arbitrations which impact the rights and so on of the third parties in theory, but in practice they don't, because the third party is not bound by the arbitration agreement. And so if you take my example, if the dispute is whether, in arbitration, is whether a contract has been agreed between the two parties, which is the subject of the arbitration agreement, there may also be a claim in negligence by one of the parties against their broker for failing to conclude the contract. The arbitration agreement will resolve as between the principals whether there is an arbitration agreement or whether there was a contract concluded, rather. What they won't do is have any impact on the relation with the broker, who is entirely entitled in court proceedings to relitigate the whole matter, even if he gave evidence in the arbitration. he's entitled to relitigate the whole matter in defence of a claim against him for negligence. So the arbitration will address the relationships between other people in that context. But it doesn't matter because the other people are not bound by it. But it's not odd in any way for an arbitration to engage itself with other contracts and make decisions in relation to those other contracts, but it only has binding effect between the parties to that arbitration. And so if you take the IFA to arbitration, which it said is the correct approach, the IFA will, in its entirety, be considered by the arbitrators in that arbitration. But the analysis which the arbitrators reach and the decision they reach will be binding only on the parties to that arbitration.
But the only issue for the arbitrators, surely, is the validity of the supply contract. They're not concerned to say whether or not the guarantee is valid.
It might follow from their findings that the findings might have the implication that it would be invalid, but that doesn't mean that issue is an issue for the arbitrators to decide within the scope of the arbitration agreement.
Well, we may be in furious agreement, but the arbitrators will have to decide under the IFA issues which, as a matter of theory, address the question of whether the guarantee is valid, because the guarantees and the financing and the supply contracts are all part of a package, and the arbitrators will receive the gamut of evidence and be called upon to decide the question as to whether there was a fraudulent scheme in relation to these package of contracts. Now, in law, their decision on this will, of course, only impact the parties to that arbitration agreement. But the issues over which they will range in order to come to their conclusion would encompass an analysis of the position in relation to all of the contracts, because that is the subject matter of the IFA. So the arbitrators will have to address that, and it will be part of the issues which they address. But some of the parties to the other agreements won't be there. But as I say, it is not abnormal for arbitrators to have to address issues arising in relation to other contracts and other parties who are not parties to the arbitration. And indeed, the consequence may have implications indirectly, but it has no direct consequence. It's the same in relation to string contracts, it's the same in relation to contracts for successive charters and so on. Issues of frustration may arise. And the court of the arbitrators would have to decide whether a particular event has for example, a frustration, has a particular effect on the contract before it, but in that context it may well consider the position in relation to other parties, other contracts and so on, but they're not there giving evidence and that decision's not binding on them. That is not unusual in an arbitration.
And under which arbitration agreements have you got the stay? Is it under all of them? Or under which arbitration agreements is there a stay?
A stay of the court proceeding?
Yeah.
Under all of them?
All the arbitration agreements?
Yes.
So all the arbitration agreements capture all the disputes?
The IFA and the IFA cover all the parties, all the contracts, and they are stayed so that the position as between each of the parties to, for example, the Pro Indicus contract can be addressed in relation to the IFA in that arbitration, and in relation to the Martin arbitration will be addressed in that arbitration, and in relation to the MAM arbitration will be addressed in that. In fact, what is happening is that artificial barriers are being thrown up to suggest this is not what the parties must have contemplated. Firstly, we say because this is the sort of thing which happens where you have arbitration agreements, you have to hive off discussion to an arbitration which may have involve issues relating to multiple parties, some of whom are not parties to that arbitration, but nevertheless have to be addressed as part of that arbitration. Secondly, we know that and the point is taken that the arbitration agreements are said to be incompatible, but in practice what has happened in this case, the fact of their incompatibility was not something which was ever identified as giving rise to any difficulties. The Court of Appeal rightly recorded that nothing turned on that, and also, or it hadn't been suggested that anything turned on that, and also, in matter of fact, when you look at the discussion in Mr. Justice Waxman's judgment of what has happened to the arbitrations, they did all end up with the same tribunals being case managed together. So a lot of the practical difficulties that would otherwise be thought to arise out of the fact that these allegations have impact or require an examination of the whole gamut of the transactions, not just the one to which the particular arbitration is subject, a lot of those perceived difficulties are actually more fanciful than real.
Yeah, so even though the ICC arbitrations couldn't be consolidated as such, if you have the same tribunal and if you in fact hear them side by side, then you can have consistent case management decisions and also, one would hope, consistent arbitral findings.
Yes. All that happens is you get 3 awards instead of 1.
Yes, but maybe the reasoning in each being rather similar.
Yes. And so there's no difficulty in practice with managing this process. And as I say, if you start with the fact that the parties are to be taken to have contemplated that the IFA and the UMIFA are capable of being and are intended to be dealt with by each of the arbitrations in each of the supply contracts, the problems that are identified in relation to the practical implications of that in relation to the other claims disappear. So the nature of the claims, the fact that they're for bribery, but that's within the IFA. That's going to have.
But all these claims, each arbitration is looking at the same matters each time round, but only for the purpose of deciding whether that particular contract is invalid. Just the same can happen in relation to the guarantee, where they've chosen English jurisdiction. You look at the same matters again, but this time just for the purpose of deciding whether the guarantee is invalid.
Yes. Well, in normal course, most issues that arise, that would be exactly what happens. Any dispute between the parties to the guarantee would be dealt with in the English High Court in a judgment that did not in any way bind the parties to the supply contracts who were not parties to the guarantee, i.e. not including the Republic, who on this analysis are parties to both contracts. But disputes under the supply contract would be resolved there. I mean, if one takes it very simply from that point of view, I'm moving on in effect to the implications of it. But if one runs through the various different implications that are prayed in aid, well, yes, you've got different proceedings under the supply agreements and the guarantee agreements, but that is what the parties had agreed. That doesn't, we have established, prevent the IFA and the UMIFA being dealt with in arbitration. Obviously, there are some people who are not parties to any of the arbitration agreements, like Mr. Safar is not party to any of the arbitration agreements. Inevitably, any dispute under the contract which had implications for Mr. Safar would have to be dealt with separately in the arbitration agreements, pursuant to the arbitration agreements in relation to the parties to the arbitration agreements, and Mr. Safar in relation to any claim being brought against him, even if it was the same or overlapping factual issues, even if it was the same or overlapping legal issues. And that is simply a product of the fact, respected by the court in this jurisdiction, that parties can choose to have issues between them arbitrated, and if they do, That may give rise to complexities and difficulties. The example I gave, simple one of the broker being the subject of negligence proceedings in relation to circumstances surrounding an agreement between principals that has an arbitration agreement, to which the broker is not a party. He's not a party to the arbitration agreement. Therefore, the proceedings in relation to him will be in court. This is perfectly normal and perfectly standard in the world of arbitration. It is not there are elements of it that are less than ideal, but it's not a basis upon which you start with an assumption that the parties must have intended by their arbitration agreement to be concerned and focused only on matters between the parties, rather than matters that could involve an investigation of the role of other parties and could involve an investigation of the position in relation to other contracts. That is just the product of arbitration agreements being entered into. If one looks at it in this way, supposing you didn't have 3 contracts, supply contracts, supposing all of the matters of supply were dealt with under one supply contract, and supposing all the matters of guarantee were dealt with under one guarantee agreement, it wouldn't be said in those circumstances, well, the fact that you've got other arbitrations between other parties is a matter which must lead you to a conclusion that the parties cannot have intended any disputes of wider gamut, such as the IFA, such as the UMIFA, such as the bribery and so on claims, to be dealt with in court rather than in arbitration, because you've got the arbitration agreement and it's accepted that it's sufficiently closely connected with the IFA, the UMIFA disputes to involve an arbitration in relation to those issues. But the consequence of it is that Credit Suisse, which is a party to the guarantee agreements, which don't have an arbitration agreement in it, will not be subject to that arbitration and will not be bound by its findings. And so although the arbitration will involve a bust-up in relation to all the factual gamut of the transactions, both the supply contract and the guarantee contract in that example, the fact is that insofar as the arbitrators make findings in relation to the guarantee, they are not binding on Credit Suisse, and vice versa in relation to the English court proceedings.
The question is whether their binding would be binding on the Republic. And this is the sort of mirror image of the argument you were having this morning. Well, if the issue in the arbitration is whether the supply contract was valid or invalid, then some findings that they may have made on the evidence along the way about the guarantee may not create an issue estoppel on that.
But it doesn't matter.
It wasn't the issue in the arbitration.
But it doesn't matter, because as between the Republic and the D6, for example, it will create an issue estoppel.
Well, you say that, but that's what I'm posing as to whether it will. If what was ultimately decided, the issue was, is the supply contract valid? And they made some findings which would lead to the conclusion that if they were applied and made the same findings in another case, that the guarantee was also invalid, but that wasn't an issue as such in the arbitration on a proper analysis of the issues of the kind we were discussing this morning.
Well, that depends upon it is different from the issues we were discussing this morning. This question of whether issue estoppel would arise obviously turns on the application of the law of issue estoppel in relation to what is a necessary element of the finding leading to the final conclusion. And if in the course of that it is necessary for the arbitrator to determine as an issue the validity of the guarantee in order to determine the validity of the supply transaction, then as between the Republic and D6, the outcome of the arbitration will be issue estoppel in relation to the guarantee, because it was a necessary step.
But it's not a necessary step.
Well, that begs the question.
Well, I know, but this is the submission you're making, that it is a necessary step. I'm just looking at paragraph 64 of the points of claim, which is an example of the IFA. And it's saying that the supply contract was a vehicle for enrichment because it would I think, provide the funds for the bribes and so on. That took us to the further information and so on. But that's not engaging the guarantee. It doesn't mention the guarantee.
I've gone through all of the references this morning, demonstrating that the IFA and the UMIFA treat the supply transactions as part of a package of measures giving rise to, they say, a fraudulent scheme. If you just had the supply transaction, nothing would ever have been concluded. You have to have the loan facility, you have to have the guarantee in order to make the supply transaction capable of being agreed.
Well, that's just a matter of fact. It's not a matter of law that you have to.
And the allegation that my clients have to meet and will have to meet in arbitration is that this package of transactions, the supply contract, the facility agreement, and the guarantee, were all agreed as part of a scheme in order to try to extract money from the Republic to pay partly bribes and partly to enrich. And that is the package, that is the case underlying the IFA and the UMIFA. It's not, and it cannot simply be, two parties entered into the supply transaction for that purpose. It's hopeless. That would never work. There'd never have been such a contract. The supply contracts don't work without the loan facility and the guarantee facility. And so any analysis under the debate about the IFA and the UMIFA giving rise to a decision binding on the parties to, for example, a pro indicus contract, will have to address the gamut of agreements and contracts as to whether or not it is, as the Republic alleges, a series of transactions which are entered into for the purpose alleged and capable, therefore, of being impugned or not. But the outcome of that analysis will be a decision binding as between the parties to the arbitration, impacting all of the agreements. And as I say, if and insofar as it is a necessary step in the arbitrator's reasoning to conclude that the guarantees were themselves objectionable as part of this scheme, then in those circumstances, as between the Republic and D6, there will be a binding decision as to the guarantee, but it won't bind Credit Suisse. So for those reasons, we do say that the starting point does need to be taken as the fact that the IFA and the UMIFA is in arbitration. You have to consider the implications of that, as the Court of Appeal did, for the wider gamut, namely what degree of connectivity it's appropriate to have by way of analysis for deciding in relation to the other issues. Now, there is a simple route, which is the route the Court of Appeal took, which is that the IFA and the IFA defences are the mirror image of each other, and the IFA defences also arise in relation to the other causes of action, and therefore if the one is in, the others are in. It's a simple and straight route, and we say unimpeachable. But even if you don't take that route, you still get to the same result, for the reasons we've set out in some detail in our case, that all of these other causes of action involve no greater or different degree of proximity or connectivity to the supply transaction than the IFA and the UMIFA allegations, because they are indeed all of a piece. I'll come back in a moment, if I may, just to pick up any additional points that I need to touch on in relation to some of the specific points that are raised by way of objection by the Republic as to why the matters in the proceedings are not sufficiently connected. We've dealt with the question of the whether the approach adopted by the Court of Appeal was contrary to authority. That in our case at paragraph 93, and that is essentially that the Republic relies upon T&N and China export, dealt with by Ruhan in paragraph 47 of the Ruhan judgment, and therefore I don't propose to take any further time on those unless the tribunal, your lordships will wish it. The second point that's raised by the Republic in relation to this point is that it would subvert rather than promote the legislative intent behind Section 9. And in relation to that, the Republic's position on the applicability of the arbitration agreements to defences is somewhat schizophrenic in its approach. If one takes their position at paragraph 105.3 of their case, they say in paragraph 105.3, footnote 96, that if one takes 105.3 first, page 59 of the bundle, the parties may intend that only the matter raised by way of defence should be arbitrated. The court gives effect to this intention by enabling the claim to proceed in litigation. This may mean that an aspect of the defence cannot be resolved in litigation in conjunction with the claim unless the parties waive their right to insist on arbitration. There is no injustice in this. It does no more or less than give effect to the parties' agreement. Well, the difficulty in relation to this is that this seems to proceed on the basis that the parties, the court has power to stay a defence, but not the concomitant claim. But there is no power in Section 9 to stay a defence. The application under Section 9 is brought by the defendants, not to...
Well, I assume this is saying that in this situation there won't be a stay of the claim, and that the fact that there is this defence, which is going to be dealt with separately, may have to be addressed by case management, but there won't be any stay. But on this third of the three possibilities.
Well, if it's recognised that the it's conceded that a matter raised by way of defence can give rise to a stay of a claim.
Yep.
And so what is being suggested is that there may be a matter raised by way of defence, which by definition is then not going to be stayed, which nevertheless means that a matter which is referred to arbitration should be nevertheless dealt with in court. Because there's no way of not dealing with it in court. There's no stay of it. I mean, one might say, well, there should be a discretionary stay, but there's no power to make a mandatory stay if that's the right analysis. Now, what the then paragraph...
well, the analysis that's being postulated is that all that's within the scope of the arbitration agreement is the defence, and not the claim in answer to which that is a defence. And therefore all you leave for arbitration on that analysis is the defence.
Well, with respect, you don't even leave that for arbitration, because there is no mechanism to stay other than by case management, not under Section 9, the defence.
Well, you don't have to leave it for arbitration, because the arbitration can... you just allow the claim to proceed. That's what's being suggested.
And you allow...
It may not be a good outcome, but there's nothing incoherent about it as a possibility, is there?
Well, it would be... I mean, just prefaced against the fact that we do not say that the Court of Appeal held there was any mutable principle, that because a defence is raised, it is necessarily the case that the claim to which it is a defence must be stayed. The Court of Appeal don't say that, and we don't say that.
Right.
So if one tries to identify what is the issue of principle between the parties, with respect we struggle to find what the difference of principle is, because neither party is arguing for an immutable, inevitable stay of the claim merely because a matter is raised by way of defence, which is subject to an arbitration agreement. So inevitably, it is still ultimately a question of determining, as the Court of Appeal addressed, without adopting any immutable principle, and we say rightly, the question is still whether the claim is within the scope of the arbitration agreement, even if the defence is. And so we accept that that's the right analysis. The Court of Appeal took that approach to the issue, and that is why we say that there is a difficulty in identifying actually in the judgment what it is that gives rise to the point of principle between the parties, which it is said the Court of Appeal got wrong. What is essentially the complaint of the Republic in this court is that they have a complaint on the facts, which they address at paragraph 107 of their case, that when the Court of Appeal came to consider whether the claims should be stayed in light of the matters that were encompassed by the defences to those claims, the Court of Appeal concluded that they were within scope. But that is simply an application of the facts of the claims to the terms of the supply contracts, arbitration agreements, determined as a matter of Swiss law, applying the Swiss law as found by the judge. And the complaint of the Republic is simply, they say, well, they got Swiss law wrong. Not in the sense that the principles of Swiss law were wrong, but the application of the principles of Swiss law to the facts of our case, they say the Court of Appeal got wrong. And we say that certainly doesn't raise any issue of principle and is no basis for challenging the Court of Appeal's judgment. There's one point that I wish to touch on at paragraph 113 of the Republic's case, where they say at the bottom of page 62 in the key documents bundle, it is unsurprising that the authorities do not support such a proposition, and that proposition is that they say there's nothing in the authorities to support the suggestion that such a matter, even if potentially arbitral, renders the claims against which the matter is raised as somehow evidentially relevant themselves arbitral matters that must be stayed. Again, we don't say as a matter of principle it is immutable or inevitable that is the case. It's simply a question on this case of applying Swiss law to the terms of the supply agreement, arbitration agreement, in the light of the facts found. And then at 113 then, at C, they say it ignores the fact that there is no certainty that such an evidential matter could ever be raised in the litigation at all. On this latter point, matters of evidence are generally determined by the lex fori. It is inherently unlikely that a party would ever intend for an entire claim to be stayed in favour of arbitration on the basis of an evidential point which, depending upon the jurisdiction seized, may not even be admissible. But again, this is tilting at windmills, because if the point is not admissible, then when it's raised by way of Section 9, the court will say, well, it's not admissible. So that issue doesn't arise in these proceedings. So it's not a matter in respect of which proceedings have been commenced concerning a matter which is governed by the arbitration agreement. So, and the point there is, therefore, this would fail at the first stage of the Section 9 analysis, namely that it's not a matter in respect of which proceedings have been commenced, if the point would not be admissible in the proceedings in any event. It is then said by the Republic that the approach of the Court of Appeal cannot stand with other well-established principles applicable to Section 9. Essentially, they raise that in relation to transactional set-off, and all that we say in relation to that is that, in effect, it seems to be treated as something of a special case, either for the reasons identified by Lord Hamblin when he was Mr. Justice Hamblin, on the basis that the transactional set-off raised by way of a counterclaim is in fact properly to be regarded only as a defence and not as a counterclaim at all. Or alternatively on the approach suggested in Ruhan, that it might be a waiver point that the claimant has forfeited the right by bringing his claim, and the defendant has forfeited his right by bringing the defence, as it were, forward, whether by way of defence or by way of transactional set-off. Therefore, transactional set-off is a somewhat different case, and we deal with that in our case at paragraph 48. I'm going to pick up just in the last few minutes a few points to complete them, as it were, in relation to some of the supposed complications which might be said to arise, which seems to underlie the factual analysis which the Republic adopts as to why these other matters may not be said to be within the scope of the arbitration. At paragraph 33 of their case, the Republic points out that the proceedings may proceed against Mr. Saffa, even though the proceedings against the respondents are stayed. That is simply not a relevant consideration for the court. That is a matter of case management for the commercial court. In this context, it's quite easy to test in this case that Mr. Saffa was brought in by amendment. As we see, the timing and so on is addressed in our case at paragraph 28. At that time, at the time of the pleading that we're concerned with in page 415 of our bundle, Mr. Saffa is not a party to the proceedings. He hadn't come in by that stage. And it cannot be said that the proceedings before Mr. Saffa was brought in were in respect of a matter which has been agreed to be referred to arbitration, and that somehow by bringing him in, they cease to be a matter that's been agreed to be referred to arbitration. The Republic can't change the proper construction of the arbitration agreements by bringing in Mr. Saffa as an additional party to the approach to the proceedings. And therefore we say that it is not at all relevant or germane as to whether proceedings against Mr. Saffa may or may not be brought, and if they are brought, whether they may or may not continue if the relevant claims are, as against the respondents, hived off to be dealt with in arbitration pursuant to the arbitration agreements with them. So also we say it is irrelevant that in theory proceedings may be pursued against the respondents by Credit Suisse in any event. That's the Republic's case, paragraph 34. As to that, we say it's irrelevant in law, because again, this is a matter for case management for the commercial court, but doesn't affect the definition of whether the proceedings are brought in respect of a matter which is agreed to be arbitrated. The question of whether the proceedings are brought against the respondents by the Republic in respect of a matter which has been agreed to be referred to arbitration can't turn on whether or not other parties choose to bring proceedings against the respondents.
But all this is implicit in Section 9, the fact that a stay is pro tanto.
It is indeed, and yes, I mean, it is recognised that you have...
It may proceed against some, but not others.
Yes.
Because the stay couldn't proceed. You couldn't stay against Mr. Saffa under Section 9. You couldn't stop Credit Suisse suing you.
But so also we say. I'm sorry, my lord.
Yeah.
But so also we say, when you come on to construction of the Swiss law arbitration agreement, these matters don't take you anywhere. These are irrelevant. If and insofar as they arise, they're dealt with by case management as appropriate. They are not matters which can properly or sensibly be said to be infecting the presumed intention of the parties.
But the reason I mentioned Section 9 is because Section 9 is built on an international understanding of how to proceed in these matters, which presumably would be in the mind of the drafters of the Swiss contract.
Yes.
So the fact that Mr. Saffer might be there, and the fact that Credit Suisse are going for you, is neither here nor there.
Yes, we agree, my lord. And further, in fact, it's neither here nor there, because if the Republic's claims against the respondents failed, the Credit Suisse claim is parasitic, and of course would therefore, in all racing certainty, fall away as well. For the reasons I've indicated, it's not relevant, but as even on the facts, it doesn't arise. And you see that from the Republic's case at paragraph 34, when they recognise, in effect, that the Credit Suisse claims are parasitic because they are contingent upon the bribery allegations succeeded, and of course if the bribery allegations against the respondents by the Republic fail, then the Credit Suisse contingent claims against the respondents premised on the bribery also fail. It's said that some significance is to be attached to the different arbitration agreements. I've touched on this already. It seems odd that the meaning of the first in-time arbitration agreement could be construed by reference to a later arbitration agreement, so that point may go nowhere anyway. In any event, the Republic had not suggested at first instance that the specific wording had any particular significance. You see that from the Court of Appeal judgment at paragraph 34, which recites that fact. They now advance the argument that the arbitration agreements are incompatible. This is the point I touched on earlier this afternoon. Mr. Justice Waxman's judgment, which sets out the course of those, is paragraphs 38 to 40 at page 842, and there is no suggestion that so-called incompatibility means any more than two different sets of rules, rather than any impossibility of all the relevant claims being heard in effect by the same tribunals at the same time, subject to all the same evidence. And therefore the perceived difficulty in relation to there being multiple arbitration agreements is more apparent than real. And it is, it is odd that when it suits them, the Republic highlights the timing discrepancy between the contracts to show that they are not a package of agreements, but when it comes to analysing the meaning of each arbitration agreement, it treats them as a package and attaches significance to the existence of other arbitral agreements, and in particular the fact of different arbitration centres in Switzerland.
Holding the arbitrations together, that would depend on agreement of the parties, would it? I mean, could it be imposed?
If you have the same, I'm afraid I can't recall whether the Swiss rules, either under the ICC or under the Stockholm rules, permit it to be imposed, because there are many arbitration rules, as your Lordship would appreciate, that whilst not permitting consolidation, permit orders to be made in relation to concurrent hearings, even where there are different parties. So I'm afraid I can't remember exactly whether the bringing together of all of those arbitrations as occurred was by agreement of all of the parties, or was imposed by the tribunals pursuant to the rules of the ICC and the Stockholm rules accordingly. The point that somehow the different arbitration agreements matters is obviously premised upon the parties having chosen to structure their agreements in a way of having three different contracts with three different SPVs. But it is a lot to read into the arbitration agreements that they therefore intended claims such as we're concerned with in this case to be dealt with in court rather than in any of their arbitration agreements in consequence. Certainly if the claims arose out of one contract alone, so if the matter were being pursued in relation to, for example, only the circumstances in which the Pro Indicus supply contract was entered into, but not any of the other contracts, it's difficult to see why in those circumstances the arbitration agreement wouldn't have been wide enough to deal with any of the other matters that are raised by the Republic. A classic example would be the suggestion that there was bribery in connection only with the Pro Indicus supply transaction. It is in those circumstances difficult to see why, as a matter of construction of the arbitration agreements, it would be said that it wasn't anticipated that such a claim wasn't to come within the terms of the clause. And so also, if in fact the three contracts had been subsumed into one contract, again, it would be difficult to see why the parties should be taken to have assumed or intended that the matter should be dealt with not by their arbitration agreements, which otherwise on their wording is wide enough to cover the claims involved, but by court proceedings instead.
Can I ask you about the quantum point that was discussed this morning and how that fits into this? Because one possibility that was canvassed this morning was that even if the claims were not stayed in relation to liability, there's still an issue that may arise on quantum, in which the value of the benefits received under the supply contracts could be relevant to the calculation of damages. And let us suppose that that is a matter in respect of which the proceedings are brought, and one comes then to ask whether it's within the scope of the arbitration agreement. Now, clearly, suppose there was a claim under the supply in relation to the supply contract itself that was being arbitrated, and let's say that Mozambique had rescinded the supply contract, and there was return of payments and benefits received. The arbitrators would have to quantify the benefits received, and that would all be within the scope of the arbitration agreement very clearly. Does it follow, though, or might that it's within the scope of the arbitration agreement for this purpose, or what do you say to the argument, which I think is one of Mr. Pillow's arguments, that just because you've agreed to arbitrate quantification of the benefits in one context doesn't mean that you have agreed to arbitrate that valuation question when it arises in the context of a complex multi-contract conspiracy claim.
Well, the starting point is you look to the wording of the clause and you look to the matter that is to be addressed in the arbitration, and you ask whether it comes within the wording of the clause before you get into presumed intention or taking it wider. Secondly, there is, of course, a question then as to how you precisely quantify the nature of the losses, but it is not, as I understand it, being suggested that there is somehow some different liability attaching to D6 or D7 or D8 rather than total liability attaching to each of them. And therefore it is not easy to see why an arbitrator would have difficulty in establishing whether the quantum for which D6 was liable, whether D7 and D8 might also be liable for that, was a matter that the arbitrator would be able to deal with. And so in those circumstances, we don't say that the context in the sense of the nature of the claim, in other words, that you somehow read out of this arbitration agreement any claim in which D6 might be jointly and severally liable with anybody else.
But even if the quantification of the damages based on the conspiracy, even if that wasn't within the scope of the arbitration clause for the reasons that Lord Leggatt puts forward, the allegation as a component of the calculation of damages that the supply contracts gave value, and that whatever the sum of damages were to be awarded for the conspiracy, that value had to be deducted from it.
That is true.
That presumably you would say would readily fall within the wording of the arbitration agreement.
That at a very base level does, my lord.
Oh, yes, I'm taking it to a base level, and then you build from there to see what else is covered by in connection with the supply contract.
Yes. And under the arbitration against D7, there might or might not be a finding that there is liability But if under the IFA, for example, and insofar as there is a finding under that, then the consequence of that, any damages claim, is something that the D7 arbitrators are perfectly well equipped to quantify. But if conversely the arbitrators in relation to D7 concluded that D7 was not liable in relation to that, then to that extent that party would not be liable. And that is part of the product of having multiple contracts with different arbitrators. But ultimately, of course, as I say, capable of being managed procedurally.
Yes.
Touched on that. Yes, any difficulty in relation to running the case against a particular defendant in a particular arbitration is, in theory, on the basis of the Republic's claim, undermined in any event, because the Republic's case is that the existence of corruption or bribery is sufficient to bring the contract into challenge, and it is not necessary to demonstrate that there was a connection between, they say on English law, the corruption or the bribery and that particular contract. And therefore, in the Pro Indicus arbitration in relation to D6, no doubt the argument would be advanced on behalf of the Republic that whether in fact the supply contract was induced by the bribery in question, it was neither here nor there, because the Republic would say they don't seek to show, nor do they show, that, for example, the guarantee was caused by corruption, whereas the supply contracts were not. Their approach to the whole thing is that all of the contracts were all impugned by the existence of corruption. And conversely, if D6 is absolved of all wrongdoing, which would of course be necessary therefore on that analysis to preserve the Pro Indicus supply contract, then the case against D6 would fail in respect of all of the Republic's claims. But that is something which is perfectly possible for arbitrators to address in relation to D6's liability and so on in relation to the other arbitrations. And then ultimately, the question is, does it make any difference? The Republic seems to suggest in its case at paragraphs 118 to 119 that it makes a difference, that the Republic might have had in mind something different in relation to the construction of the arbitration agreement by virtue of the fact that this was, they say, an alleged complex international fraud against the Republic. But this, in our submission, draws a very fine line as regards the intention of the Republic when construing the clauses. Is the position different if the Republic had not used SPVs, but had entered into the contracts themselves on any view? We say it can't be, because in the circumstances we are assuming for the present purposes, the Republic is a party to those contracts. And again, is the position different if the alleged fraud had related only to, for example, the Pro Indicus supply contract and related financing, rather than being, as the Republic seeks to say, an alleged complex international fraud? Would that make a difference? Answer, we say, of course not. All of these matters are capable of being addressed and resolved by arbitration. Supposing the alleged fraud had been limited to the contribution to campaign funds for the former Defence Minister, now President Newsy, and he'd been involved in only one contract relating to the naval vessels. In those, I say naval because of course it was his position as the Minister of Defence at the time. If that was the limit of the complaint, is it then being said, well, that's not such a large international complex fraud as to have been contemplated by the parties to be outside the scope of this agreement, because it is perfectly possible for the Pro Indicus supply contract, or the relevant one in relation to the naval vessels, to be taken into account and dealt with as a matter of the arbitration agreement, because it's not sufficiently international or complex enough as a fraud. It approaches the construction of the clause by giving far too much scope or analysis to assess what the parties' intentions were rather than reading the clause. And one is imputing an enormous amount, obviously without any evidence, because one is taking presumed objective intention. And we say that to start to say that because the Republic is a republic, because it's a large-scale international fraud rather than a small-scale international fraud, that all of these matters somehow can be taken by the court as affecting the presumed intention is not possible. And finally, the proper law of the tort claims, obviously it begs other questions. The Republic approaches this litigation on the basis that it can rely on the English law of bribery in bringing these proceedings in England. But obviously the question is, can it? And is this what must be taken to have been its intention when entering into the arbitration agreements? The connections with English law are tenuous. Some of the agreements are English law, but one might think the Republic might, if anything, have intended that questions of whether there has been corruption of Mozambican officials, which seems to lie at the heart of their claims, might rather have been matters of Mozambican law rather than English law. So it's not clear why the Republic should argue that its intention or presumed intention at the time of the conclusion of the supply transactions would have been dispute resolution of any corruption allegations under English law in the English courts, for which the Republic is now contending, rather than under the arbitration agreements, which at least they agreed to when entering into the supply transactions. And there are, as we've indicated, significant differences between English law and Mozambican law on corruption. So if you ask yourself the question, would you expect any question of corruption impacting the validity of the conclusion of these contracts to come within the arbitration clause, one would rather expect the parties to say yes, because of the wording of the clauses and the circumstances in which they'd entered into them. So we say the position of the Republic is untenable in light of its correct conclusion on the IFA and the UMIFA, and it therefore follows in relation to the other claims. The Republic contends that if its claims were so closely connected to the supply contracts, the respondents would say that those claims were governed by Swiss law, the proper law of the supply contracts. In our submission, that is a complete non sequitur. The respondents acknowledge that the Republic's claims are torts governed by the proper law of the alleged torts. And of course, the proper law of the torts, we say, is Mozambican law, but it is perfectly normal for a tort claim arising in connection with or in relation to a contract to be governed by a different system of law from the underlying contract, but still be caught by the scope of the arbitration agreement in the underlying contract. So the fact that you've got one system of law for the contractual obligations and another system of law for the tortious or extra-contractual, but nevertheless within the scope of the arbitration agreement claims, doesn't in any way impact upon the presumed intention of the parties. Lord, unless I can assist further, the only thing I was going to say was in relation to costs we haven't mentioned.
Well, the costs will be dealt with totally separately after a judgment has been handed down.
Grateful.
Thank you very much. Yes.
My Lords, a few points which may not take all that long, subject, of course, to any further questions your Lordships have. Can I first of all make a correction to something Mr. Matthews said, which is potentially rather material? My Lord Hodge, you asked whether the only money that the SPVs undertook responsibility for and the Republic guaranteed were the prices paid under the supply contracts. Mr. Matthews agreed with that and confirmed it. I think he'd forgotten something quite important, that the amounts advanced to the SPVs under the facility agreement from the banks far exceeded the purchase prices under the supply contracts, because they included two things. One is so-called lender arrangement fees, which you might be surprised to hear involved $50 million or more going to Credit Suisse under the Pro Indicus contract alone, but which was rolled up into the loan and ended up being owed by, therefore, the SPV and guaranteed by the Republic, just under Pro Indicus. So there's at least a $50 million gap between purchase price and funds.
And those were called?
They were called lender arrangement fees, my lord. I can't show you the numbers and the pleadings because it's in the Credit Suisse pleadings that aren't before the court. We can supply the material if it's in dispute. And I'm giving a figure that is on the conservative side because I'm not including such fees in relation to Martin and MAM, or indeed other lenders who were involved as well. But there's 50 million at least in respect of Credit Suisse on Pro Indicus. And in addition, because of what happened, what was agreed, caused to be agreed in respect of the Pro Indicus deal, there were so-called Palomar running fees agreed.
What are they called?
Palomar running fees, my lord. Palomar was the company, our vehicle I mentioned yesterday, which was the joint venture, supposedly, between the Credit Suisse deal team individuals, the three people who received the money we say were bribes, and the Privinvest people, to sort of, it appears to be a consultancy and finance house. But by virtue of the operation of certain arrangements in relation to Pro Indicus, they agreed a document which made Pro Indicus, the SPV, liable for these fees, which was, I think, a percentage of the outstanding amount of the loan annually, payable by the SPV to Palomar for the benefit of Privinvest and Credit Suisse people. That amount, I think, I can't remember exactly what it was, 1 or 2% a year or something. It was defined in the guarantees so that it was captured by the guarantee the government gave as a finance document, and a claim is now being made against the Republic under the guarantees, under the Pro Indicus guarantee by Palomar, the vehicle, for $37.8 million in those fees, and interest amounting to another $8 million. So those are also aspects of the liability of the Republic under the guarantees, which have no bearing or no relationship, as far as we're concerned, to the purchase prices under the supply contracts. And so when one is considering, for example, the quantum of loss by exposure of the Republic under the guarantees, there is at least, even on this basis, approaching $100 million that can't be said to be referable to anything that happened under the supply contract in terms of quid pro quo for services and goods. We would say, therefore, a fortiori cannot be the subject of any credit against which to be given in respect of whatever value those goods and services have. I should just correct one point. I said there were a range of fees. They were actually both a range of fees and prepayment of interest, which were called subvention fees. The point isn't a material one. All it means is that this 50 million that the SPVs ended up paying back to Credit Suisse and are liable for under the loans, for which we, the Republic, are now guarantors, apparently, have nothing to do with the supply contract purchase price. My Lord, can I then answer a second, or making a second clarification to assist something that Lord Hodge asked during the course of Mr. Matthews' submissions, and that was about the way in which we plead our relief in relation to the different guarantees, and why we say the Martin guarantee is invalid as well as the Pro Indicus guarantee, but not the MAM guarantee. If that's still, it may still be troubling the court. The reason is this: we seek a declaration that the Pro Indicus guarantee is not valid, legal or enforceable. You see that in the prayer, for example, at page 449 of the bundle. And the basis for that is that the Pro Indicus guarantee was entered into primarily, we'd say, without authority, and additionally because it was illegal under both English law and Mozambican law, and so forth. And we summarise the legal consequences in terms of the Pro Indicus guarantee at paragraphs 125 to 128 of our pleading, 441 of the bundle. And if you look, my Lord...
441?
441, my Lord. You'll see there, if I could just ask you perhaps to turn it up, that you'll see... And that's because the Pro Indicus guarantee is extant, in the sense that it is still said to be valid against us. But if one looks at 441, we make a similar allegation in relation to the Martin guarantee at 125.2. And we say there that we allege that the Martin guarantee did not give rise, and that's in the past tense. And the reason we say that is because the Martin guarantee was overtaken by what's known as the Martin exchange, whereby the Republic's liability under the guarantee was exchanged for its liability under a series of loan notes. And that, I think, happened in 2016. And there's due to be a restructuring of those notes again in 2023. But the point there, my lord, is there is no Martin guarantee at the moment anymore onto which an existing declaration would have any effect. It's been superseded. Nonetheless, of course, we say that our liability that flowed from the guarantee, which has been translated into the loan notes under the exchange, is still a liability for which the defendants are liable in the torts of bribery and conspiracy and so forth. It's still given.
Who are the loan notes owed to? Credit Suisse?
I think a variety of people. I'm not.
Are the loan notes impugned? Their validity?
Not in our claim, they're not. No.
So you're going to be liable under those, and so that is only a damages claim.
That is only a damages claim.
Only a
damages claim. So it's for the same damage as would have flowed under the guarantee, but it's been replaced in this way.
Yes.
And there's a separate claim that arises out of that, which is a slightly separate point, my lord, because we say that as part of the restructuring, a further deceit was practiced on the Republic by the Credit Suisse parties. We plead that from paragraph 143, page 445, which you'll see is for specific costs of the restructuring into the guarantee, from the guarantees into the loan notes. And that deceit, my lord, paragraph 143 on page 445.
Thank you so much.
445. That deceit is one of the unlawful means we've looked at in paragraph 133.6, the very final of the 6 unlawful means in the conspiracy allegation. So that's why we impugn the Martin guarantee in the sense that it was invalid when it was entered into and would have been void, but it's been translated into loan notes and the claims have therefore changed slightly. But as against Privinvest, not materially. That's my only point. And the reason, of course, the MAM guarantee doesn't feature in the same sense as either the Pro Indicus or Martin guarantees is because the MAM guarantee was between the Republic and VTB, and that's a separate issue altogether. So I hope that's of some assistance in terms of clarifying where we are. We seek declaratory relief, both as to the as to the Pro Indicus guarantee, which is alleged to subsist, but also in relation to the Martin guarantee as it was. Now, that may not be necessary, it may be too...
Well, actually, you don't.
Well, no, you're right. You're quite right, my lord. We in the prayer don't, but we allude to it in 127, which is slightly inconsistent. But it is not a substantive point. I hope that's clear at least. Now, can I just mention something about the governing law point that my learned friend finished on, that he mentioned yesterday? I can deal with it quite quickly. This application only concerns claims made in English law. That was what was before the judge, and that's what the Court of Appeal stayed, or would stay, subject to the parties' points. So the question of reasonable foreseeability of defences, or even actual defences, is only relevant insofar as they're defences to an English law claim. And of course it's not a defence to an English law claim to say that something would be a defence were the claim brought under a different governing law. That is simply to say that there is a different claim against you, potentially. Well, it's either to say you can't make an English law claim, that defence doesn't engage anything to do with the supply contracts, or it's to say, were you to make a non-English law claim, we would have a defence against you.
But have you not pleaded again alternatively in Mozambican law?
We have now, my lord, yes, that's right. So the question arises, as I mentioned at the beginning of yesterday's hearing, or early on, quite what the status of those is, because of the case management arrangements my learned friend has alluded to, that the pleadings have been amended without prejudice to this application, because it all might fall away at trial if we're not parties anyway. And so one has on the pleadings Mozambican law alternative claims in respect of which no stay application's been made, and which will fall to be decided in which at the moment are sort of in limbo, pending the decision on parties.
Yes, so you're saying that as far as we are determining this appeal, we are under APOC, and APOC is purely English law.
Yes.
And whatever the parties have been up to thereafter in revising and re-revising and so on is not our concern.
Yes, I think I can say to your lordships, you don't need to worry about that. That is a matter for the case management judge, perhaps thankfully.
Thank you.
But the point of substance that I'm on, of course, is that it's no good for Privinvest to say here, well, if there were Mozambican law claims, we might have a defence that might engage the supply contracts. That's utterly irrelevant. And to tie it up with a point that Mr. Matthews made at the end, that means the relevant question when you're asking about the parties' intentions as to the scope of their arbitration agreement isn't whether they would expect claims under English law, and if so, how they'd be framed or what the defences might be. The relevant question is, when faced with claims under English law, does the arbitration clause require them to be arbitrated because they have something to do with the supply contracts? And so that's the relevant question, and the answer to that is, as I submitted yesterday, no, because no part of any of our claims has any dependence upon any validity or otherwise of the supply contracts. So that, I hope, disposes of the governing law issue. Now, on English law of bribery, which was the subject of my learned friend's exchange with, in particular, my Lord Legate this morning, having agreed that the principles I set out yesterday were indeed uncontroversial, Mr. Matthews essentially sought to apply them wrongly and to mischaracterise them, because you'll recall he said it really matters whether it's a commission and whether it's legitimate or illegitimate or wrongful or not wrongful. Those are all red herrings. They're all labels that are totally irrelevant to the law of English law of bribery. The only relevant question is whether a promise or payment was secretly made that might give rise to a real possibility of a conflict of interest. Now, whether that's the payment for a car, a holiday, a consultancy service, a political campaign is entirely irrelevant. The quid pro quo is only relevant if it means that there can be no possible conflict of interest. So, for example, you can imagine a situation where someone's an agent and they happen to be buying a car from the counterparty, and the car is market value, sold at market value. And you might say, although I wouldn't concede this if I were in the case, that there was no possibility of a conflict of interest because they'd bought a market value car. The truth is there could well be a benefit in that situation. You can imagine getting the car quickly or having its use when they might not. Anyway, it doesn't matter. The point is, the only relevant question when you're talking about English law of bribery is not whether there was a quid pro quo, it's whether there was a sensible risk of a conflict of interest. And that's why it won't help my learned friend to say they were genuine political contributions or they were for consultancy services. Because if it is obvious that if you pay someone $5 million, even for consultancy services, you are putting them in a position where their personal interests conflict with those they owe to their principal. And that's why in the Fiona Trust case, Mr. Justice Andrew Smith said, rightly in my submission, that you can bribe someone by paying them their wages or by giving them a job, by letting them moonlight for you. Because indeed you can. And you'll see that reference, incidentally, it's also in the Noviship case, where Mr. Justice Christopher Clark says as much, and that's at paragraph 106 of Noviship at page 2796 of the bundle. And of course, around the edges, where there is a genuine quid pro quo, you might be able to argue that there is no benefit that corrupts. But we're not in that case, because my learned friend doesn't even suggest there was a valuable quid pro quo given. least if they're political contributions, it's hard to see what is the quid pro quo. Why does that not, ex hypothesi, incentivise someone to act in their interests or your interests rather than their own principles? Because they're either promised it or they assume there's going to be more. Anyway, that's the analysis I urge on your lordships. Now, in dishonest assistance, can I just deal with that relatively briefly, because my own friend focused on it again. I perceive that the court may have correctly understood the way we put the case, but in case it's not clear, can I say it in these terms, perhaps? For our claim in dishonest assistance, the dishonesty is supplied by the bribery. So, obviously, I have to prove dishonesty on the part of the assister and a breach of duty in relation to the agent. And for our purposes, we say Privinvest's dishonesty will be established by the bribery. And I said yesterday that the dishonesty is irrebuttably presumed in English law. So that's enough for us. That only leaves, therefore, what we plead at paragraph 137.3 of the particulars, which is the specific act of assistance that we rely on in relation to Privinvest, which is D6 to D8's actual entry into the contract, the supply contracts. Now, the only issue that engages is the fact of entry and whether factually entering that contract had a causal connection to the breach of to an assistance in a breach of duty. Because there's no dispute that contracts were entered. The question is, did entry into the contract simpliciter materially assist a breach of duty by any of the Mozambican officials? And obviously, you can test it quite simply by positing Mr. Chang and the guarantees. Mr. Chang was, of course, in breach of duty, we say, both by having been promised bribes prior to Pro Indicus and then continuing to advise and keep them secret. But of course, upon actually receiving the money after Pro Indicus, there was a further breach of duty by Mr. Chang, and that breach was taking the money and not giving it to his principal, not accounting for it to the Republic. Now, it's obvious in my respectful submission that latter breach of duty, at least, was materially assisted by the Privinvest defendants entering the supply contracts, because it's Mr. Matthews' own case that there was a factual linkage between the supply contract causing the facility agreement, causing the guarantee. In other words, on the Privinvest defendant's own case, as a matter of causation, the signing of the supply contracts triggered a series of events that led to the guarantee being signed, which led ultimately to Mr. Chang getting his bribe paid a few months later. So this is not a question that could remotely be arbitrated under or in respect of the supply contracts. This is a question of whether a simple physical event, if you like, the sitting and signing and what ensued, had a material effect in assisting a breach of duty. In our respectful submission, it clearly did. And it would be quite a strange situation, I might submit, if the claim in bribery, in the tort of bribery or in restitution, could be established, but its equitable counterpart depended on something entirely different. But I don't think I need to go into that particularly any further. And just to be clear,
your point, as I understand it, is that the only relevance of the supply contract was that it was entered into by the parties.
Yes,
in this case, and that isn't a matter of controversy.
Yes.
So there'd be nothing to send to arbitration.
Yes.
Did you or did you not enter the supply contract?
Yes.
Everyone's agreed.
Yes. The only question is, factually, did that start a chain of events that was close enough in causal terms to amount to an act of assistance for the purpose of perfecting the equitable wrong of dishonest assistance? And I do respectfully object to the suggestion that this has not been a clear position that the Republic has taken for a long time. I won't bore the court, but it's very clear if one looks at paragraph 62 of our skeleton below. That's at page 1007. And at what I said in terms of the Court of Appeal about our case on this, at both day 1, page 130, which is at bundle 175, and at day 2, page 40, at page 209, that we were saying, and perhaps I just read to you to tell your lordships, when we specifically confronted the dishonest assistance claim in the Court of Appeal, on day 2 of the hearing, I said, my Lady Justice Carr said, so you're saying there can be dishonest assistance by an entirely legitimate contract? And I said, yes, absolutely, my lady, absolutely. For this purpose, the contract could be the best contract in the world. The question for the court, that has to be heard in court, is did the conclusion of that contract factually assist the acceptance or promise of bribes by the Mozambican official? So we were all clear as to what our case was. And there was no suggestion that paragraph 137.3 was in any way unclear. It's notable, you may think, when you look back at it, that 137.3 talks about the entry into the supply contracts without any mention of the IFA. And that's because when we wanted to rely on the IFA, we specifically did mention it. And you'll see that in the UMIFA allegation, which did specifically say that the unlawful means was not just entry into the supply contracts, but it was entry when they were instruments of fraud. And there was always a material difference. So again, that is what we say about that, and that's why we say there is an obvious error in the analysis the Court of Appeal brought to bear on that aspect, even though the argument was squarely in front of them. Turning to what my learned friends called the ground 2 points, perfectly accurately, there was just one point I wanted to mention about Tomologan, my lord, and specifically in relation to one of Lord Hodges' questions. Because in case it's not clear, it does appear that the Singapore Court of Appeal in Tomologan did reject, at least implicitly, the discrete controversy test that was in broad terms adopted by the Australian court in the Tanning decision and others. If one looks at para 114 of Tomologan at 3846, you'll see that the court says the line between the discrete controversy test and the so-called mere issue test is so fine that it's illusory, and that's why they prefer the substantial and but not peripheral or tangential approach. I just wanted to mention it because it does appear that if your lordships were to decide that the concept of discrete controversy is part of English law, it wouldn't be in accordance with, I think, what the Singaporeans have done so far.
Which paragraph was that, did you say?
114, my lord.
Thank you.
Well, it's treating them as synonyms.
Well, it's
so fine that the distinction is so fine that it's illusory.
Yes, but that's, I think, my lord, with the distinction is between the discrete controversy and the any and all issues point.
Mere issue.
Yes, a mere issue point, as opposed to what it ends up, I think, alighting upon, which is the search for the substantial but not peripheral and tangential.
Yes.
We may be dancing on the head of a pin, but I just apprehended that the court might be attracted by the discrete controversy.
Well, I mean,
label.
a discrete controversy is not enough in itself, because if it's a defence, it has to be relevant to the claim made, yes, for a start. So there has to be relevance,
yes,
and then there also has to be a degree of substance to exclude Chief Justice Menon's tangential and I can't remember the peripheral.
Yes, that's right.
So there's nothing wrong with discrete controversy as long as substance and relevance are part of the formula.
Yes, well, we respectfully agree with that. It's just important to keep the qualifications to that in mind in my submission.
Yes.
Can I just turn briefly to the quantum issues and pick up what my learned friend said this morning, and also what my Lord Legate asked him about this afternoon. And we do say, in case it's not clear, that it's not enough to say that the quantum issue, if I can call it that, could be arbitral and therefore should be stayed, and that in one world it might have been intended to fall within the four corners of the clause. Firstly, I should say, quite important not to call it the quantum issue, and your lordships were quite careful, I think, mostly to not call it that. Loss is too wide in my submission, partly, of course, because of the point I made at the very beginning, which is there are tens and tens of millions of loss that have nothing to do with the purchase price or the value of the goods. So that's important. Even in the damages claim, they're going to have nothing, there's no relevance to the supply contract inquiry to tens and tens of millions, possibly more. The correct approach, I think, I would submit, is my Lord Hodges' approach, which is to ask what the dispute is as to the value, if any, of the benefits received or enjoyed by the Republic, if it's a party to the contract, by virtue of the goods and services that were supplied, or potentially those that the benefits that should have been but weren't.
No, what I was I was really suggesting that I wasn't saying all quantum goes to arbitration. No. What I was suggesting was there might be a relevant and substantial issue as to the benefits that the Republic received directly or indirectly from the supply contracts, and that will be a component of the quantum.
Yes.
And the rest of the quantum claim might have to be case managed, awaiting an arbitral outcome on that point.
Yes, well, in that case, I respectfully agree, and it's just important to bear that in mind. The other reason, of course, is that there are other heads of loss. In addition to those fees that I mentioned earlier, there are the restructuring costs in relation to Martin that I mentioned that are separately due, or separately, there's a separate liability for, nothing to do with the supply contracts per se. And then, of course, then there's the macroeconomic claim, which is very large, which also has nothing to do with the supply contracts. So your Lordship's right. One would have to case manage it according to whether, in law, the benefits under the supply contracts can be credits against certain of those heads of loss, or all or any of them. You might, for example, be able to get to a judgment on the macroeconomic losses or the fees losses, because as a matter of law, they're not losses against which supply contract benefits fall to be allocated. That's not a matter for today, but it's something for the judge to decide. Now, but that really was a preface to what I wanted to reiterate, which is that in our respectful submission, the real analysis here, when one's looking at those benefit valuation issues, is that one starts from the fact we say this is a matter of a defence point, which you can't use automatically Section 9 to stay. You have to translate it somehow into a matter in respect of which the proceedings are brought. Now, if one gets to that stage, then the key element of the analysis, if one assumes that one even gets to the stage of being able to analyse it as a matter in respect of which the proceedings are brought, the key element of that analysis, of course, is whether the parties did agree that that matter must be arbitrated in this context. And that falls to be answered by reference to whether rational commercial parties and nation states would have intended that one of very many sub-issues in a bribery and conspiracy claim, and perhaps even one of many sub-issues in a sub-issue of those claims being the quantum of damages flowing from those claims, all the others of which do not fall to be arbitrated, should nonetheless itself be hived off and arbitrated separately, peeled off, if you like, and fragmented.
But isn't Mr. Matthews not correct that one can postulate all sorts of circumstances which may not have been envisaged at the time? But we have to come back to the wording of the arbitration clause, and if there is a sufficient connection between the issue or discrete controversy and the supply contracts, then that part of the dispute between the parties has to be abstracted from the litigation and resolved by arbitration.
Well, that's to posit the answer to my question, which I wouldn't accept, my lord, because I think one has to ask the question genuinely, if one is construing an arbitration clause as implicitly having a one-stop shop presumption within it, why would commercially rational parties agree that it would cover a fraction of a much, much wider case that only goes to a sub-issue on quantum, and agree that that was, in any context, no matter how it arose, would always have to be arbitrated? That is the question. In my respectful submission, the answer is to be supplied by asking whether it furthers or hinders a one-stop shop approach. But it is logically a question of interpreting the clause, not presuming that because it falls within it could fall within its corners, it must have been intended to be arbitrated in every context.
But how does the one-stop shop approach help here? Because Section 9 expressly envisages pro tanto extraction of claims from a litigation.
Yes, my lord, but only claims that the parties have intended had only to be arbitrated and not ever, in any circumstance or in the relevant circumstance, litigated. And I go back to the submissions I made yesterday on the authorities. There are authorities and therefore examples of cases where issues that certainly would have to be arbitrated in one context are proceeded in court or litigated in court in a different context, and the courts are happy with that. And as I mentioned, the Panama Canal case is an example of even where one agreed agreed to be substantial, and one that would have to be arbitrated were it to arise in one context was held to be perfectly legitimately decided in court. So there is a contextual analysis to this, and of course one has to do it at two levels. The first one is it a matter in respect of which the proceedings are brought at all? And as I said, my first line would be to rely on that, to say that a sub-issue on quantum is not fairly characterised as a matter in respect of which these proceedings are brought, just because there's a dispute as to one part of one element of it. But even if it were, the authorities show that you then apply the second question and ask, well, in this context, can they be taken to have assumed that there would be the very opposite of a one-stop shop, whereby there would be a granularity of this nature peeled off and arbitrated in a different shop. I don't think I can assist you further, my lord. Those are my submissions.
I see that.
In relation to the
do we have a more particularised quantum claim or loss and damage claim?
Yes, we do now, my lord. Can I just ask one of my genius to give me the reference to the way it's put in the re-amended claim, and I'll give you that, because it's very much more fleshed out now as to where it all fits in.
When I looked at the pleadings, it looked to me as if this point about the value of the services and assets was raised as a matter for which credit should be given, rather than as being a necessary part of your calculation of loss.
Yes, that's certainly.
I think they accept that, as it were, prima facie, the damages would include the amount payable under the guarantees, assuming liability and so on, and then go on to say, but credit would need to be given for this, that, and the other, rather than saying you haven't pleaded a loss. Yes. The loss being the amount payable under the guarantees less the amount which you should be pleading. That's the way it arises.
That is the way it arises. Yeah. That's right, man. Yeah. Can I just mention the conceded concession point, paragraph 102 of the Court of Appeal's judgment? My learned friend sort of sidestepped it by saying, well, it's not appealed in this court, so it doesn't matter. But that's not right, of course. It follows from what I have said on the main issue that the Court of Appeal was wrong as a matter of law to treat a defence that is incapable of giving rise to a legal defence as rendering the claim to which it relates arbitral within the meaning of Section 9. That is squarely an issue of law, and that's the central issue in our submission, where the Court of Appeal went wrong. If that is right, then the Court of Appeal was also wrong to override the concession in relation to the two unlawful means that only concern Credit Suisse, because they are matters par excellence that have nothing to do with the supply contracts. They are the matters, indeed, that are the furthest removed from the supply contracts of anything. And if you only have to posit, for example, an unlawful means conspiracy in which they were the only two means alleged, the error the Court of Appeal fell into in our respectful submission bites on that a fortiori, in a sense, that compared to anything else. And then can I finally just deal with an answer my learned friend gave to one of the questions from my Lord Richards about the conspiracy claim that we plead in paragraph 132 of the pleading. My Lord may remember that Mr. Matthews agreed with you when you said, so what you mean about 132 is that the conspiracy to defraud the Republic was a conspiracy to defraud using the invalid uncommercial supply contracts, amongst other things, and Mr. Matthews agreed. But of course, my lord, that is the description of the conspiracy encapsulated by the UMIFA in 133.3. And that is the case we've disavowed, subject to whoever's a party to these agreements. So it's not relevant to say now, well, do you allege a conspiracy to defraud using the supply contracts? Because the deletion, in inverted commas, of 133.3 means we do not advance that case against Privinvest on the premises of which you're aware. So once you realise that the IFA and the UMIFA have gone, it's not part of our case to say that the instrument of the defrauding referred to at the beginning of paragraph 132 is the supply contracts. We have disavowed that in terms. And that, importantly though, does not then impinge upon the conspiracy claim we plead using all of the other unlawful means, or any one or more of them. Because taking the bribery on its own, for example, simply the first ground, it's no less of a fraudulent conspiracy to defraud the Republic and injure it by unlawful means if the only unlawful means was bribery. Bribery is the tort of fraud, and the conspiracy is to damage the Republic by exposing it to this vast liability under the guarantees. So
that's the injury, as it were, the primary or most obvious injury is the exposure under the guarantees.
Yes. It can only sensibly be the injury, the legal injury, the injury of legal relevance, because that's the only exposure the Republic has on its case. And as I've said, a fortiori, if you posit that we'd only pleaded 2 and 6 as the unlawful means, they clearly have absolutely no connection whatsoever with the supply contracts, but they wouldn't be any less a good plea of conspiracy in English law, actionable at the suit of the Republic, against both Credit Suisse and Privinvest. And then, literally finally, the matters of case management and arbitral management, my Lord raised at the end. It is true, of course, if you have a multiplicity of contracts between similar or related parties, you might be able to manage them together. And to a degree, that was achieved. I mentioned, I think yesterday, though, that the parallel case management broke down in various respects in our case, because orders in one arbitration were not complied with, and the tribunal stayed the proceedings pending, for example, posting of security or whatever. And suddenly, what was the best of intentions, even between antagonistic parties, rendered the whole process out of kilter. There was no simultaneous progression of the cases. But the most important point isn't what actually happened; it's what might have happened. It's what one might indeed posit were you to imagine that the parties were told at the time they were contracting that they were going to allege fraud and bribery against each other. And you say, well, are you going to cooperate to make that an easy process? Well, why would you, if you're the alleged briber? Certainly. But it's not a foregone conclusion. Any one of the parties to any one of those arbitrations could have appointed a different arbitrator in every single one of them. And that would have meant the hearings couldn't even be heard together in the same room, let alone the same heads. And no one else could have done anything about it. So it is true. And I should say, you might say the answer to that is, well, if they're all in the same group of companies on each side, as it were, the same minds are controlling the arbitrations, they'd be slightly mad to mess it up in that way. But that's not an answer, because, of course, the control over these companies could change in the meantime. And indeed has, because the SPVs are now in liquidation and they're being run by a liquidator. So they could have been run by a different liquidator. Anything's possible. But it's not an answer to the one-stop shop violation that we say this sort of claim gives rise to say, well, it's possible in an ideal world that the fragmentation can be ameliorated. No one could have foreseen that was a certainty, let alone perhaps a probability. Those are all my submissions, if
So have you got the reference to loss and damage?
Yes, I've got one reference. The loss and damage starts at paragraph 152 of the re-amended pleading at page 1187 and is scheduled in new schedules 3 to 5, which start at 1225. And I'll go into rather a lot more detail than we've identified hitherto. One correction to something I mentioned. I said I'm told that the Palomar running fees were being claimed by Palomar. In fact, they're being claimed by an assignee from Palomar. But it's the same point, and it doesn't make any difference.
I think you were going to produce a document that made clear which paragraphs or sentences in the pleading are not being pursued against these defendants.
Okay, my Lord.
I mentioned that yesterday, and I think your discussion today about the conceded concession shows that it is quite important that this court, in determining this appeal, knows what it is you're now saying against the Privinvest parties, and I'm sure they'll welcome it too.
Right, my Lord, I'm sorry if I was, I misunderstood then in that case, what you said yesterday. We had a bit of a debate and we concluded that you were asking for some references you were ultimately given. But can I just clarify that you'd like a document identifying paragraph numbers to which the IFA, on which the IFA bites, the concession bites, effectively?
What you now say, you're pleading against the Privinvest companies having conceded IFA and UNIFA.
Yes.
And you can explain, if you wish, that certain paragraphs are remaining, and because they are relevant,
yes,
they are relevant against Credit Suisse and so on. But
I see.
What I think we need to know, having regard to APOC rather than RR APOC, we need to know what it is, what are the proceedings which you now are bringing against Privinvest.
Yes.
Having regard to the concessions made.
In a sense, I suppose, my Lord, it's a summary pleading of what we would have pleaded had we started from today, rather than as it's developed, but and only against Privinvest. We understand.
It's what goes out, or what goes out as against Privinvest.
We understand.
We need to know. I think it would save us a lot of searching. You will know, or be very quickly able to ascertain the consequences of your concession. And I think that's something that the court would like to leave to you. Obviously, you'll give Privinvest the opportunity to see what you're saying before you submit it to us.
We will.
Thank you very much. Well, it only remains for the court to thank counsel for their submissions in this legally interesting case. Whether or not it will make a blind bit of difference to what happens in the autumn seems to be rather uncertain, or perhaps it is certain. But thank you for presenting the cases in a succinct and helpful way, and thank you also to those who have assisted in the preparation of the written cases and in the preparation of the documents for this appeal. We will take away and discuss your submissions and produce a judgment in due course.